Good morning, everybody, and thank you so much for coming to our CSW side event. We know it has been a long and crazy 2 weeks, so we greatly appreciate you being here this morning, this afternoon, this evening, wherever you are tuning in from. My name is Larissa. I'm the International Engagement Directorate for the Migration, Youth, and Children platform, and we are thrilled to be putting on this side event on addressing gender apartheid towards an integrated system of protection. We have a great lineup of speakers, so get your notebooks out because there's a lot to learn today. And we also want to give a shout out to our co-sponsors before we get into anything. Thank you to the Government of Canada for supporting this event, the United Nations Working Group on Discrimination Against Women and Girls, the Global Justice Center, the Center for Migration, Gender and Justice, as well as the Migration, Youth and Children platform. So without further ado, let's get into things. I wanted to start off with two questions to frame what inspired this event. And hopefully, by the end of this event, you will have answers to these two questions. So firstly, what is gender apartheid specifically? And secondly, how can the international community protect women and girls living under gender apartheid? And when we say protect women and girls living under gender apartheid, we not only mean in Afghanistan, but we also mean throughout the potential displacement that may be a result of gender apartheid. So this event will be tackling different forms of protection within the country of Afghanistan, as well as Afghan women who may have had to be forcibly displaced because of the situation that they were facing. So to give some background about what we will be tackling in this event, gender apartheid has gained prominence in contexts where the systematic and institutionalized exclusion of individuals based on gender in particular is prevalent. So when we typically use the term apartheid, we've seen it in the context of South Africa when it comes to race. We will now be talking about it in terms of gender in particular. And specifically, this event will focus on the situation in Afghanistan under the Taliban regime since 2021, which has been characterized by practices of gender apartheid and which has severely restricted the rights and freedoms of women and girls. As a legal concept, gender apartheid has emerged in international criminal law as well as international human rights law, specifically through proposals for it to be included in the Prospective Crimes Against Humanity Treaty, which we will be talking about today, as well as in the published Committee on the Elimination of Discrimination Against Women, General Recommendation number 40. We'll also be talking about today what is called gender persecution. And this has amounted to what has been described as gender apartheid as well. And it forms the basis of the cases at the International Court of Justice, which has been taken up by Canada, Germany, Australia, and the Netherlands under CEDAW. So thank you again. Shout out to Canada for co-sponsoring this event. And it has also formed the basis of the case at the International Criminal Court, referred to by Chile, Costa Rica, Spain, France, Luxembourg, and Mexico. So we will also be talking about these cases and updates on what is happening in these courts. So just to give you an agenda of what we will tackle today, firstly, we will talk about the concept of gender apartheid. What is it? Secondly, the international cases involving gender-based persecution and how gender-based persecution differs from gender apartheid. Next, the proposal to include gender apartheid in the Prospective Crimes Against Humanity Treaty. The realities of Afghan women living under gender apartheid and giving agency to Afghan women as well. And lastly, protection mechanisms for women and girls forcibly displaced from Afghanistan. We want to make sure that Afghanistan is in a situation where women and girls do not have to flee. They do not have to be forcibly displaced. But this event will also look at what happens when they are. What protections can we offer them? So that is a little bit about what we will be tackling today. I do want to give some introductions before we get into everything so that you can see some of the amazing speakers that we have today. My name is Larissa. I will be your moderator today. I am from the Migration, Youth, and Children platform. I graduated from Boston College in 2021, and I've spent my past 4 gap years as part of Harvard Law's Junior Deferral Program, working on legal advocacy and human rights in different regions of the world, specifically in Jordan, Kenya, Japan, and Thailand. I've served as the UN Youth Representative for an NGO based in Tokyo called Human Rights Now for the past 3 years. And since January, I have also served as the International Engagement Director for the Migration, Youth, and Children platform. Our first panelist will be Gisu Nia. Gisu is a human rights lawyer. She is specialized in international criminal law and human rights and a legal advisor to the End Gender Apartheid campaign. Nia started her career in The Hague, where she worked on war crimes and crimes against humanity trials at the International Criminal Tribunal for the former Yugoslavia and the International Criminal Court. She lectures and publishes widely on global human rights developments, as well as the rule of law in post-conflict and transitional societies. After Gisu, we will have Tess Graham from the Global Justice Center. Tess is a legal advisor at the Global Justice Center. She previously wrote and edited for the legal blog Just Security in New York and served as a human rights technical advisor to ALEF, Act for Human Rights in Beirut, Lebanon. She holds a JD from New York University School of Law. After Tess, we will hear from Leda Amrullah. Leda is an Afghan independent researcher. She is a Fulbright and Chevening Scholar from Afghanistan. She earned a master's in international affairs from the Bush School of Government and Public Service at Texas A&M University through a Fulbright scholarship, specializing in national security and diplomacy with a concentration in women, peace, and security. She also holds a master's in international relations with a focus on international development from Brunel University, London, through a Chevening scholarship. At the heart of Leda's work is the belief in freedom of choice, the power of individuals to shape their own futures. And Leda also wanted to introduce herself with a quote from one of her beloved teachers who said, "We have freedom of choice, but we do not have freedom of consequences." This principle is driving much of Leda's commitment to advancing education, economic empowerment, and professional development for Afghan women and men. After Leda, we will have Dr. Lara Susan Golsorki. She is from the Center for Migration, Gender, and Justice. Dr. Lara Susan is an assistant professor of political science and global affairs / gender and sexuality studies at the University of Portland. Her work is concerned with issues that pertain to the intersection of migration and gender and is broadly situated within the fields of comparative politics and international relations. She is also the founder and executive director of the Center for Migration, Gender, and Justice, a nonprofit NGO. And as a scholar practitioner and as a migrant woman herself, Dr. Golsorki combines expertise in the fields and lived experience in her academic and policy work. And lastly, we will be having our closing presentation from Ivana Kristic. She is from the UN Working Group on Discrimination Against Women and Girls. Ivana assumed her functions as a member of the UN Working Group on Discrimination Against Women and Girls on 1 November 2023. She is a full professor at the Faculty of Law, University of Belgrade, where she teaches international human rights law and other related courses at the Department of International Law and International Relations. She coordinates the Legal Clinic for Anti-Discrimination Law, as well as the group of experts of the Faculty of Law, which aims to supervise the implementation of the Istanbul Convention on preventing and combating violence against women and domestic violence. So as I said, we have an amazing lineup of speakers, and I don't want to take any more of the time away from them. So without further ado, I will hand it over to Jisoo to talk about gender apartheid, as well as the cases involving gender persecution.
Thank you so much. And thanks for having me here. And hello to everybody who's joined. I'm going to share my screen just to share a few slides so you don't just have to look at me talking. Let's see if this works. There you go. Share.
Yep, we can see it.
Perfect. I don't know what that is. Do you know?
I think if you click allow, it may.
Sometimes that's what's used to hack meetings. So I hope that's not the case. So let's give it a shot and hope that's not the case.
Okay, perfect. It went away.
Looks like it's not the case, hopefully. That happened on one of the last Zooms I was on. True story. Okay, great. And then I'll minimize that. All right. So I'll give about 10 minutes to explain a little bit about the concept of gender apartheid, which has been a concept that Afghan women, Iranian women, and others have been describing for decades, but where there's become a really strong legal push to basically actually formally codify the crime. So I think I don't need to give too much introduction into what we're dealing with when it comes to the Taliban and the increasingly deteriorating situation for women inside Afghanistan, I think even this list is now outdated of the restrictions on women in successive decrees that essentially ban women from even speaking in public, from using public parks, clearly from education and from many forms of employment. So gender apartheid. We have traced that the term gender apartheid was used for the first time in the 1980s. I can get a bit into the different individuals who've used it over the years, but it's been a descriptive term, a term that describes a situation in which women in a society are essentially subjugated and relegated to a subordinate part of the society for purposes of the regime that is in control, entrenching its power. And although this has been a term that has been used for decades, the interesting thing and how some of this came about was that there's been a lot of discourse around this. If you read some of the media in Farsi, Dari, Persian, they'll use the term apartheid agenciati to really describe what they're dealing with. But when I spoke to a lot of the activists who've been using the term, this was about 2 years ago or so, when I spoke to some of the activists using the term, I realized that a lot of people had already assumed that this was codified because this crime is obviously so horrific that I don't think there was even the assumption that this wasn't something that was, formally on the books, that a prosecutor could indeed charge against individuals who are actually committing this crime. But that was an interesting discovery to see that a lot of people thought it was already a crime, but it isn't. It's not formally a crime. And so part of the End Gender Apartheid campaign that I'm a legal advisor to, but there are many other campaigns that have also started that all have the same common goal of codification. The goal is to really make this a formal thing. So as probably many of you know, the crime of apartheid was really born out of the experience of apartheid-era South Africa, in which white South Africans were dominating and were seeking to dominate through an institutionalized system, Black South Africans and non-white South Africans. And at the time, the 1973 Apartheid Convention was adopted at that period to really acknowledge what this crime is. And it defines apartheid as inhuman acts committed for the purpose of establishing and maintaining domination by one racial group of persons over any other racial group of persons and systematically oppressing them. In our view, in the view of many individuals who are working to codify this crime, if you swap race for gender in this same definition, it accurately describes the situation of women living under the Taliban today. And so that's really been the animating idea behind trying to seek codification of this crime. I'm going to, oh, right. And so for just a little bit about the etymology or where this word came from. So apartheid, when we actually started discussing this concept and kind of socializing it a bit more broadly, it was interesting to see that there was a bit of a generational gap in understanding this crime. So a lot of people who were at the time when we began, so that was like a little more than 2 years ago, a lot of people under the age of 40 hadn't actually heard the term apartheid before or didn't really understand what it meant. They had maybe heard about something in connection to Nelson Mandela, but they didn't really know what it meant. And I thought that was so fascinating because obviously a lot of decision makers around the world, for them, they'll be above the age of, a lot of are above the age of 40. And so it has a specific resonance, harkening back to that time. There are memories of, reading news about a global movement that came to really end that practice in South Africa alongside all the internal activism that was happening at the time in the country. But a lot of people of a certain age won't necessarily know the term because they didn't grow up reading those headlines and because there hasn't always been a dynamic discussion globally about what really happened there and to try to memorialize that. So it's really fascinating to discover that a lot of people were not aware. Now that has changed a bit currently because of the situation with Israel-Palestine. There's been a new generation of individuals who have come to know what this this term is and to maybe know a bit of the history in South Africa, but we actually discovered that a lot of people were unaware. And so part of this effort has been to also discuss that example and what happened and how the situation in Afghanistan is now a parallel of what has happened there and has many parallels to that situation. So just to discuss a little bit about some of the key things that have happened in this effort, and then I'll unshare my screen and continue giving a few of the key highlights. The idea really was, let's bring a lot of women together who've been calling for this, the women who are directly impacted by this, and have them tell the world, you know, what they want to see happen, the change they want to see happen. So like I said, a lot of the women had already assumed this was a crime. When they heard that it wasn't formally codified as a crime, they really wanted to get behind wanting to ensure that it would become a crime. And so in March 2023, there was a group of more than 100 Afghan and Iranian women activists that came together to say that they want the international community to recognize this as a crime and to formally codify it. At the time, we indicated that there were several pathways to doing that. One would be to add an additional protocol to the Apartheid Convention of 1973. Bit of a difficult pathway, would take some time. The other pathway was to look at the Rome Statute. So the crime of apartheid is codified as a crime against humanity in the Rome Statute, which animates the International Criminal Court. And the pathway to an amendment to the Rome Statute is a bit difficult. It can take some time. And if you've been tracing, you know, other campaigns to amend the Rome Statute to include, for example, the crime of ecocide, you know that it can be a years-long effort, and it can be an uphill battle. The pathway that we thought was probably the most expeditious, at least in terms of a legal campaign, was to try to have gender apartheid included in the Crimes Against Humanity treaty. That has the draft treaty that has actually now been sent for negotiations as of last November by the Sixth Committee, the legal committee at the UN. I know that Tess on the panel will be talking a bit more about that, but we identified that as perhaps the route that would be the quickest, though the timeline is still prospectively for finalization of text and adoption in 2029. But we identified that as probably the quickest because it's a global treaty that has not yet, where the text has not yet been finalized, it hasn't come into force, hasn't been adopted, so probably the route that we want to take. After we issued that open letter in March of 2023 with all these prominent figures, we saw that we started to quickly gain momentum around an idea that had previously been viewed as somewhat radical. And so there are different UN experts that came out and supported this. I note that we have someone here on the panel from the UN Working Group on Discrimination Against Women and Girls. They've obviously called for it to be recognized as a crime under international law and have issued guidance around codification. Quite critically, there's been many figures associated with the dismantling of apartheid in South Africa who've also come out and openly supported this, including Graça Machel, Nelson Mandela's widow and former First Lady of South Africa and women's campaigner, very strong women's campaigner in her own right, who's very much said that the situation in Afghanistan that is affecting, you know, women and girls very much parallels the situation in South Africa. I will X out of here for now and then start to just share a few more key things before getting into the ICC and ICJ. You can no longer...
Can't see your screen, yeah. And you're muted for some reason, it just muted.
Okay.
Perfect.
All right, great. So in terms of what has happened that's really critical, there was a legal brief that the Global Justice Center, who's here in this panel, and the Strategic Litigation Project at the Atlantic Council, which I head up, that we sent to UN missions in on October 5th, 2023, that really laid out what the gap in international law is and why gender apartheid would fit that gap. It gave a definition of what gender apartheid is. It gave reasons for why it's so critical to codify this at this juncture. And initially, as I said, this was somewhat of a radical idea. Of course, women's rights defenders had been discussing it, but I think a lot of the initial reaction we received was, why do we need this crime? We already have gender persecution. Why do we need to have gender apartheid? Doesn't gender persecution cover most of that? And the response to that is not really, because gender apartheid is dealing with a very specific structural system that is institutionalized, and where the regime that is in power is very much using the subordination of a class of persons to entrench their own power. So in apartheid era South Africa, that was exploiting Black South Africans and non-white South Africans for their manual labor to keep the economy that only benefited white South Africans robust, and to really increase, GDP and keep those things strong. In Afghanistan, women serve as child bearers and child rearers. They have been segregated and deprived from many aspects of society, and are not given the choice to live the way that they wish to live. But their function in the society is still very critical for the purpose of the society continuing. And so, you can't really do away with that segment of society. Rather, you wish to institutionally oppress them. And so that specific, it's sort of a distinct intent, and it animates that system in a very different way. And we would argue that that's how it's distinct to gender persecution. And it is a gap in the law, because it's not recognizing that very, very real situation that Afghan women and girls are dealing with. The good news is that now 11 states, a cross-regional group of states that includes Chile, Philippines, Iceland, Australia, and others, have all agreed that gender apartheid should be, or have signaled that gender apartheid should be included in the Crimes Against Humanity draft treaty. And so that's very encouraging, to go from no states and for the concept to not be socialized at all among states, to have 11 states and of a cross-regional nature really supporting this. Doesn't sound like much, but obviously in the legal world, that's quite a lot, because you're dealing with legal advisors at foreign ministries and others that really need to sit with the definition, grapple with this, and it's not as easy and quick as a political statement, right? They really need to see whether or not they can agree to this moving forward. So that's quite encouraging. Malta, thank you for Malta's leadership. They actually have also advanced a definition of what they would like to see in the treaty. And so the timeline now is that there will be, I won't get too into the weeds of the timeline, but basically in 2026, there will be opportunities to really engage around this and to ensure that there are amendments that address gender apartheid in the treaty. And hopefully we'll have finalization and adoption in 2029 with any luck, and adhering to that structure. With that said, I want to note that obviously that timeline is several years away. And so Afghan women are not stopping at just waiting for that moment. They're also looking at a number of other routes to have gender apartheid be recognized under international law, including gender apartheid potentially being charged as a crime against humanity of an other inhumane act at the International Criminal Court. I think that probably some folks here know that the chief prosecutor at the International Criminal Court actually applied for arrest warrants against Taliban officials in January for the crime of gender persecution. And so this was a long-awaited application. He's applied for those arrest warrants. A pretrial chamber is now reviewing that. Usually it can take anywhere from a month to several months in the case of Israel-Palestine, but typically it'll take around a month to 3 months for something like that to be approved. So we're now in March, so I'm hoping that we see an approval of those arrest warrants soon. But that's a place in which ideally one could start to look at an acknowledgement of gender apartheid. And so a bit of a different route for that. Another potential pathway for acknowledgement is through the proceedings that might happen at the International Court of Justice. And so we saw an announcement from Germany, the Netherlands, Australia, and Canada on September 25th of last year, saying that they would be taking the initial steps to hold the Taliban accountable for violations of women's rights under CEDAW, under the Convention on the Elimination of All Forms of Discrimination Against Women. And so, there's been some discussion on whether or not that would only have to do with right to education or some of those rights, but there's been consultations with a broad range of civil society actors from Afghanistan with these governments. There's definitely a bit of advocating with these governments to ensure that there's more of a holistic look at what is happening to Afghan women in addressing that matter. In the media, it was reported that a case has started at the ICJ. That's not exactly the case. There's about 6 months of negotiations that happens first. So there's been this announcement. There's about 6 months of negotiations. If those negotiations with the Taliban don't lead to anywhere, then it moves to an arbitration phase. If that is not satisfactorily resolved, then it would go to the complaint phase in which a complaint will be formally brought. So we're a bit of a ways away, but it would obviously be everybody's dream if the Taliban said, you know what, great, we're going to comply with all of this. That seems a bit unlikely given their posture and given what they've done over the past few years. So we would anticipate that there will be a complaint moving forward at the ICJ. In that framework, there would also be the ability to discuss gender apartheid, to discuss the elements of gender apartheid, to discuss this institutionalized system that is repressing women and girls for the purposes of entrenching the regime's power. So there will be an opportunity to discuss that there as well. There's a number of other efforts that are being looked into, including a soft law declaration about gender apartheid, including looking at a UN General Assembly resolution that could bring in a lot of different states to make pronouncements on that. We've seen resolutions from the European Parliament that acknowledge the need to codify gender apartheid. So there's different ways in which it's being recognized, and those ways will continue to move forward and to try to build some jurisprudence and build more global acknowledgement around that. But it's off to a good start. If anybody wants to know how they can get involved, you can also visit a website, endgenderapartheid.today. I might just drop it in the chat box here. There's a lot of materials on there, including the legal brief that GJC and my organization have issued that really goes into some of the elements. And you can also follow us on social media. We give a lot of regular updates on the End Gender Apartheid page. I'll link it all in the comment box. Definitely follow and stay in touch if you want to get involved. It's a decentralized movement with a lot of different actors working on it, and everybody is working on it in their own way. Nobody owns this movement. It belongs to all the incredible activists and international allies that are pushing this forward.
Thank you, GC. Definitely drop all of those resources in the chat. From the Migration, Youth, and Children platform side, I will say a lot of us were not yet born during apartheid South Africa. And so this is a term that we are not so familiar with. And so I really appreciate you giving us the definition from the start, from the historical way that it has been used. And I think we can all say that it not being a crime under international law is something that everyone should be able to get behind. So we will definitely be here to support the movement in any way we can. And thank you for listing the strategies of how we can get this into international law. So I will shift now on to Tess. I had the honor of seeing Tess present at the UN just the other day on this exact topic. So Tess will be giving us a presentation specifically focused on the proposal to include gender apartheid in the Crimes Against Humanity Treaty. So Tess, I will hand it off to you.
Great. Thank you so much. And thanks to Gisu for both this wonderful overview and for your leadership on this issue and the coordination work that you do with the campaign. So I am going to give a little bit of an overview on the Crimes Against Humanity Treaty process and how the gender apartheid, the movement to end and codify gender apartheid fits into that Crimes Against Humanity campaign. So the initiative to codify or to institute a Crimes Against Humanity treaty began years ago with the recognition that we have treaties that criminalize or that institute state responsibility to prevent and punish war crimes and genocide, but we don't have a comparable treaty on crimes against humanity. So this is a legal gap that has created the opportunity for impunity in states, for example, that have not ratified the Rome Statute of the International Criminal Court, and also this gap even in states that have ratified the Rome Statute. It leaves uncertainty in the legal responsibility of states for preventing and punishing crimes against humanity. The ICC is about individual criminal responsibility. It's very important. That's where you see people being brought to justice for their individual criminal culpability. But the culpability of states for failing to protect their populations from various crimes against humanity, including, in our view, gender apartheid, that state legal responsibility has been lacking or unclear. So the Crimes Against Humanity Treaty Initiative seeks to fill that gap. This initiative started with civil society activism, drafting, including valiant initiatives by our dear friend Layla Sadat, who always needs a shout out in this area. She worked tirelessly with others to begin this process, and then the International Law Commission took up the call and drafted the draft articles on crimes against humanity. These were presented to the General Assembly, which sent them to their legal committee, the Sixth Committee, as Gisu has alluded to. So once they were in the Sixth Committee, they sat there for about 5 years. And the draft articles included some provisions that were more progressive or more that would provide strong protections for the most vulnerable people, including protections against gender-based violence, such as gender apartheid. But the draft articles do not include gender apartheid right now. Let's be clear about that. So these articles sat in the Sixth Committee and were discussed, debated, but never moved forward until, again, as Gisu alluded to, last year in November, we finally had a breakthrough after many years of sort of punting and discussions. So now we have this timeline that will move the draft articles forward to actual negotiations where the legal terms will be worked out until there is a final treaty text that states will be adopting and ratifying. So our goal now is to ensure that that treaty text is as progressive and advanced and strong as possible, especially for the Global Justice Center, that a high priority being as progressive as possible on gender. So I'll sketch out a little bit also the timeline, just to say that we have a little bit of time in which we can hope to and work to influence state positions, because ultimately it will be states who draft and adopt this treaty. So we have until 2028 before the actual negotiations begin, and they'll wrap up in 2029. And so our task now is indeed to influence those state positions. GJC collaborated with a variety of different organizations and individuals, scholars, activists, advocates, survivors, and people who fill all those boxes at the same time. We produced 5 different briefs, legal briefs in 2023 that tackled specific gender inclusion topics within the treaty, areas where we thought that the treaty needed the draft articles, rather, that the ILC had forwarded to be considered by the UN. there were 5 areas where we thought that those terms, the terms of those draft articles, could be improved. So those 5 areas included gender apartheid, as well as the codification of reproductive violence and the strengthening of the definition of forced pregnancy that's currently in the draft, the codification of the criminalization of the slave trade, which is at this point an international crime, but not included in the crimes against humanity draft articles, the codification of forced marriage, which likewise has been recognized as a crime against humanity, but has not been explicitly included in any of these treaty texts. So we think it should be explicitly included. And an overarching proposal to improve and strengthen victim and survivor rights, protections, and involvement in the treaty process. So I'm happy to speak to those other proposals, but I'll keep the focus on gender apartheid for now. Within our proposal for the inclusion of gender apartheid, we proposed a specific definition of gender apartheid as being the subjugation of one or more gender groups the dominance of one or more gender groups over another gender group or groups. There are other definitions that are being proposed, and we welcome the conversation around all of these definitions. The key, as Gisu alluded to, that led us to want to propose this particular definition is that we want to preserve and buttress and really participate in the strong legal prohibition on race-based apartheid. And in order to make as little change as possible to the definitions of either racial apartheid or then to map it into the definition of gender-based apartheid, we think this is a strong definition. So we can also talk more about definitions, but we won't go too in the weeds on that. Another point that I think is important to make in this legal conversation is that although Afghanistan is the example, sort of par excellence of gender apartheid in the world today, this definition is by no refugees, migrants, etc. This is not an Afghanistan specific definition. Instead, oh, did I get cut off?
It's a little bit
Hello?
fuzzy. We can't, now we can see you. Perfect.
Okay. Yeah. Okay. Hopefully a passing cloud. So this is not an Afghanistan specific definition. It would be, frankly, strange and inappropriate in international law to have a legal rule that applied only to one state. That's not how international law is supposed to work. Instead, this is a definition that can and should be applied to any cases of gender apartheid that occur in the world, just as the definition of racial apartheid can and should be applied beyond South Africa, including to the situation in Palestine. So I think that's an important point, because this is not a question of the international community targeting or, attempting to sanction Afghanistan in some specific way. It is a response to the policies of gender apartheid that the Taliban government has instituted. Finally, I wanted to also highlight, as Gisu did a fantastic job, obviously, as always, of illustrating why gender apartheid is different from and needs to be separately codified to gender persecution. These are two distinct crimes that very often coexist, but because international criminal law is both about punishing perpetrators, but also about communicating international norms, what is acceptable behavior in the international, I think positive, that we have the practice of cumulative charging, where you have potentially one set of facts that can lead to multiple legal charges. So for example, cases of as both a form of in a crimes against humanity context, for example, could be a form of sexual violence that constitutes a crime against humanity. That could also amount to torture. That could, if it results in pregnancy, lead to charges of forced pregnancy. If it led to forms of, if the particular intent is present, you could have that same act, that same factual basis lead to charges of genocide, extermination. We have a long practice of cumulative charging. So there is no problem with finding that a set of legal facts constitutes both gender persecution and gender apartheid. And I think it's important to note that because it is not true that this crime would sort of displace or take the position of gender persecution. They're both distinct crimes. And as Gisu noted, they are they have a different intent in many cases. So I'll wrap up just with the note that this is potentially a very inclusive treaty-making process. The Crimes Against Humanity treaty process is ongoing, and we have opportunities to become engaged for civil society that will run from many public events that will be held this year through there will be preparatory committee meetings and working group meetings in January 2026. We need to strongly encourage states and basically hold their feet to the fire to show them and tell them that we are watching and that we are concerned about these issues, and we have a stake, and we have really legal recommendations. We are not just sort of asking for generic lip service. So I would invite all of you to continue your involvement and to reach out to Gisu on the issue of gender apartheid in the Crimes Against Humanity Treaty and the Global Justice Center on overall advocacy, as well as these other topics that we have been advocating for. So thank you so much.
Thank you, Tess. I think it's so important that we not only found this gap of crimes against humanity not being codified in international law, but even going on a deeper level. But the 5 that you listed, including gender apartheid. And we are from states all around the world who are joining this call right now. And as Tess said, we need to hold our states to this so that when this treaty does get adopted in 2029, that we make sure gender apartheid and the other 4 draft articles are also included. So thank you so much for that comprehensive advocacy strategy for us. I think we're all leaving with a mission of what we need to do. I will now pass it over to Lida to give us a presentation on the agency of Afghan women and the reality that sometimes Afghan women are forcibly displaced because of the situation that is going on in Afghanistan right now.
Thank you. Thank you to my colleagues, Tess and Gisu. That was very informative and very timely. So today, as an Afghan woman, I stand alongside countless others, activists, former political figures, athletes, and academics, striving to address the urgent cries of Afghan women for justice, dignity, and many other fundamental rights systematically denied to the Afghan society, to them by Afghan society. Like many Afghan women, I have reflected deeply on troubling question: why Afghan women subjected to such brutal discrimination and violence? Why Afghan men complicit and desensitized to the suffering of their mothers, daughters, and sisters? After much reflection, discussion, and analysis, I have come to uncomfortable but necessary realization. The oppression of Afghan women is not just a result of systemic, cultural, or political forces. There is something deeply ingrained in the way Afghan society conditions men and women to accept this imbalance. Before I elaborate, I want to clarify that I'm not dismissing the complex struggles Afghan women face due to systematic, structural, and social issues designed to keep them chained. However, I argue that beyond these systemic structural barriers, there's an additional factor that exacerbates this oppressive situation, making it extremely difficult for Afghan women to lead dignified lives. To change the situation for Afghan women, we must recognize two essential truths. First, the oppression of women did not begin with the Taliban. Second, it will not end with them. The Taliban have doubled down on the restrictions, but the roots of gender inequality run much deeper. Even before Taliban's return to power, Afghan women face systematic discrimination in their homes, schools, and workplaces. If the Taliban disappear tomorrow, the mindset that subjugates women will still remain unless we confront it directly. This is why the struggle for women's rights in Afghanistan cannot be reduced to political regimes alone. It is a battle against deeply entrenched beliefs and structures that have shaped Afghan society for centuries. This additional painful factor is the glorification of sons and disproportionate burden placed on daughters. This condition begins in the childhood within families that hold daughters and sons to vastly different standards. In many Afghan households, mothers do not provide care for their sons. Instead, they serve their sons. Boys are raised as kings, while girls are raised as servants. A boy's mistakes are excused, overlooked, or dismissed, while girls' missteps, real or perceived, can lead to irreversible consequences. A boy's reputation is his own. A girl's reputation belongs to the entire family, making her both a sacred symbol and an object of control. The burden placed on Afghan women is immense. They are expected to uphold family honor, adhere to rigid moral, religious, and social codes, and bear the consequences if they falter. Afghan society demands their chastity, obedience, and silence, while simultaneously allowing their suffering, exploitation, and erasure. Women who dare to break these unwritten rules are not just criticized, they are broken by them. This is not an exaggeration. It is painful, undeniable truth. In many ways, Afghan women themselves knowingly or unknowingly raid their own oppressors. Breaking this cycle requires a fundamental shift in how Afghan families raise their children, holding their sons to the same moral and ethical standards as daughters, and rejecting the notion that women's worth is secondary. Yes, there are Afghan families who raise their children equally, but they are exception, not the norm. However, let me be clear, this does not mean that women are solely responsible for their own oppression. Systematic change is also necessary. Women changing their mindset is a powerful step, but it must be accompanied by policies, education, and social reform that dismantle the system that enables male dominance. We cannot dismantle oppressive systems without first dismantling the mindset that upholds them. As for me, I speak here today as an independent, empowered Afghan woman because of my faith. Islam, not culture, not tribal traditions, gave me my rights. Contrary to the propaganda and demonization, my religion taught me that freedom is God-given, and no man has the right to take it away. The Quran does not teach oppression. It does not teach male superiority. What it does teach is accountability. One of the greatest tragedies of Afghan women's oppression is that it's enforced under the guise of religion. In a country where the regime uses Islam to justify its restrictions on women, the most effective way to fight back is for women to learn their faith, take it seriously, and challenge the lies weaponized against them. Afghan women must reclaim their Islamic rights, rights that grant them dignity, freedom, and agency, not servitude and silence. The Taliban do not own Islam, nor do they have the authority to dictate its interpretation. Their use of religious pretexts to subjugate women is a direct contradiction to the very principles of justice, equality, and mercy upon which Islam is built. This is why the fight for Afghan women's freedom is incomplete if prominent Islamic scholars around the world remain silent, if it is their religious duty to speak up and challenge the falsehood the Taliban spread in the name of Islam. Their silence is an act of complicity in the systemic oppression of most vulnerable members of society. Islam does not belong to the Taliban, nor is confined to Afghanistan. The damage caused by their distorted version of Islam extends far beyond Afghan women. It affects Muslims globally, fueling Islamophobia and reinforcing misconceptions about Islamic teachings. This is why their falsehood must be openly challenged, not just by activists, by religious leaders who have a moral obligation to defend the integrity of their faith. If the world truly wants to support Afghan women, the solution is not only political intervention, but also religious discourse. The battle of Afghan women's freedom must be fought not just in courts and governments, but in mosques, religious institutions, and the very spaces where faith is taught and interpreted. Afghan women do not need outsiders to dictate their liberation. They need the truth of their own religion to be restored. Finally, I want to address an important point. In discussing the oppression of Afghan women, we must not fall into the trap of demonizing all Afghan men. regardless of their political or religious views. Demonization has never led to liberation. It only prolongs the suffering. If we truly want change, we must build bridges, not burn them. And liberation begins with self-awareness. To translate these few ideas into meaningful change, I propose the following actions. First, expanding educational opportunities for Afghan women. Governments and institutions worldwide must increase scholarships for Afghan women and simplify visa and travel processes for them. Making education more accessible is a direct challenge to the Taliban-like restrictions and investment in Afghanistan's future. Second, correcting the global misrepresentation of Islam. The international community must invest in spreading awareness of Islam's true principles through movies, documentaries, and educational broadcasts. This is crucial for Afghan women who are denied access to formal education and left vulnerable to misinformation. Third, holding Muslim countries accountable. Muslim majority countries that claim to uphold Islamic values must be called out and shamed for ignoring Afghan women's plea for dignity. Fourth, shifting the Afghan diaspora's approach. Instead of solely demonizing the Taliban, the Afghan diaspora must shift its focus towards engagement and negotiation. A confrontational approach has yielded little progress. Strategic dialogue may offer more effective solutions. And finally, my favorite, visa restrictions on Afghan men. The international community should refuse visas to Afghan men unless they travel with a female guardian. The same rule the Taliban apply to Afghan women. So this is my take on it. Thank you.
Thank you, Lida, for that extremely powerful statement. When Lida and I first talked about what she would be presenting at this, we had a really in-depth conversation that we didn't want this event to just victimize Afghan women. And I think a lot of events at CSW that we've seen pose Afghan women as these like perfect victims who need saving. And we really wanted Lida to give this sort of statement to show that Afghan women do have agency and they are peacemakers on the ground contributing to their own empowerment in Afghanistan. And so thank you, Lida, for giving that extremely powerful statement and for also sharing some of your own lived experience with the topic. So thank you. We will be moving on now to our next speaker, Dr. Lara Susan Golsorki, who will be giving us a presentation on the legal implications of gender persecution, gender apartheid, and asylum, specifically focusing on Afghan women who have had to flee and be forcibly displaced because of the situation that they were facing in Afghanistan. And I will share my screen so that there will be a presentation. Yeah, feel free to start.
Great. Many thanks for the kind introduction, Larissa. Thanks to all of the co-organizers of this event. And thanks to my fellow panelists for these important insights on the concept of gender apartheid, the inclusion of gender apartheid in the prospective crimes against humanity treaty, and the realities of Afghan women living under gender apartheid. My notebook is filling up, so thank you so much for all the insights that have been shared so far. As part of my contribution to this discussion, I will outline 5 considerations about how to create an integrated system of protections. I want to pick up on the title of today's event with a focus on international refugee law and establishing what has been kind of referred to as general risks of gender-based persecution that are tantamount to what has been described as gender apartheid, where the definition has been used as the systematic and institutionalized exclusion of persons from different areas of life based on their gender. So again, wanted to frame that my contribution will be coming from the field of international refugee law, where I situate my expertise and experience. The first consideration pertains to the addition of gender as a protected ground in the refugee definition. Gender currently does not constitute a standalone ground for protection under the 1951 Refugee Convention, which is the principal treaty on asylum. The convention defines a refugee as a person who fears persecution based on their race, religion, nationality, political opinion, or membership of a particular social group, and who is unable or unwilling, due to said fear, to return to their country of origin. And so absent of gender being a standalone ground for protection under the convention, the UN Refugee Agency, or UNHCR, has published several gender guidelines for the application of the convention, notably the 2002 Guidelines on Gender-Related Persecution. And these guidelines define gender-related persecution in terms of refugee status determination, including persecution based on gender, sex, and sexuality. The guidelines explicitly affirm that it is an established principle that the refugee definition should be interpreted with an awareness of gender dimensions in order to accurately determine claims to refugee status. Despite this assertion for a gender-responsive interpretation of the Refugee Convention, only a few states have actually included gender as a protected ground in their refugee definition and national asylum law. And proposals to add gender to the refugee definition, as I suggest here, as a first consideration of how to create an integrated system of protection, they're not new, and they remain disputed. So in brief, while some legal scholars argue that gender shares commonalities with currently protected grounds, others argue that exactly because of these commonalities, there's no need for a so-called sixth ground of protection. And outside of the discussions of the how, there's also, outside of the discussions of the why, there's also the question of the how. How should this addition approach, as it's often called, how should it take place with different approaches existing and emerging, such as in reliance on international human rights law on gender, for instance, through CEDAW. And I'll speak more to this in a moment. So that's the first consideration that I would like to propose. The second consideration of how to create an integrated system of protection involves the refinement of established grounds of protection inclusive of gender and of specific relevance to gender apartheid and asylum and the situation of women and girls in Afghanistan and in Iran are the established grounds, protected grounds of religion, political opinion, and membership of a particular social group. So I'll briefly sketch these. In terms of religion-based claims, gender-based persecution can be determined in cases where religion assigns particular gender roles or behavioral codes that are not fulfilled, whereas the protected ground of political opinion connotates aspects of gender-based persecution in cases where views are contrary to those espoused by dominant political groups and/or the political system and are presumed on gender-related matters. And as you can imagine, there's quite complexity to this when we're then talking about actual refugee status determination. And similar complexities can be found pertaining to the category of membership of a particular social group, not least because the Refugee Convention does not explicitly define what membership of a particular social group entails or how a particular social group is constituted. Yet, this category presents the most frequently applied when it comes to asylum claims based on gender, precisely because of its vagueness and openness to interpretation, if you wish. So in this way, when we're considering the refinement of established grounds of protection inclusive of gender, for purposes of an integrated system of protection, the category of membership of a particular social group appears most conducive, based on my research, to address gender apartheid, in part because of case law. And case law presents the third consideration that I would like to briefly discuss. The application of case law as it relates to matters of gender-based persecution in asylum forms this third consideration. And while the role of the ICJ and the ICC in the context of gender apartheid has already been discussed by my colleague Gisou, I will focus here on the role of the Court of Justice of the European Union, or the CJEU, in international refugee law. The CJEU was the first international court to actually interpret the Refugee Convention. And as such, the court holds significant expectations, if you wish, to shape international refugee law through progressive interpretations of the convention. And this was most recently shaped and exhibited in a decision by the CGEU on joint cases of 2 women seeking protection from the Taliban regime in Austria. So in short, the CGEU was asked to examine, for one, whether the situation in Afghanistan amounts to persecution due to the accumulation of restrictive measures on women's rights, and 2, whether it is sufficient that a woman is affected by such measures merely on the basis of their gender. And the court's answer to these 2 questions was yes and yes. More specifically, the court held that gender and nationality alone are sufficient to grant asylum to Afghan women and girls, given the, and this is the language that the court uses, absent of actually speaking of gender apartheid, but describing it in a related way, noting that the deliberately and systematically applied measures that deny Afghan women fundamental rights related to human dignity on account of their gender amount to what can be considered gender-based persecution. And so then the question, of course, is why does this matter to creating an integrated system of protection? Because the CGEU's decisions are binding upon EU member states where similar cases might arise. The nuance then here lies in the regional scope of case law, again, unlike the ICC and the ICJ. Nevertheless, I would argue that this decision holds tremendous importance for addressing gender apartheid in the context of asylum. This then brings me to the 4th consideration in creating an integrated system of protection. And this consideration bears on the connection between international refugee law and international criminal law. International criminal law and international refugee law have been closely linked around the notion of persecution, a term that we've heard frequently used already. Persecution constitutes a crime against humanity as per the Rome Statute, and it forms the basis for grounds of protection as per the Refugee Convention. So there's the linkage there. And this historical linkage and relationship around this Rome Statute, it's of particular note in terms of gender-based persecution, because the drafters of the statute were actually influenced by international refugee law, which has acknowledged gender-related forms of persecution since 1985. And again, this then leads me to suggest that an integrated system of protection may well rest on this relationship between international criminal law and international refugee law, particularly in light of the development of a Crimes Against Humanity treaty that my colleague Tess spoke to. However, here again, we have to look into different views, particularly concerns in terms of the extent to which international criminal law should and actually can inform international refugee law in the refugee status determination process. And again, varied perspectives exist on the matter, particularly as it pertains individual and country-wide risk assessments of protection, which are key when we're talking about international refugee law and granting asylum. So again, 2 perspectives kind of exist in this discussion. Some argue that international criminal law can provide insights on the level of persecution in respective countries and thus the functionality of the national legal system, which is essential for countrywide risk assessments in international refugee law, such as establishing general risks of gender-based persecution, for instance. The other view asserts that the 2 areas of law are distinct from one another and that cross-reference should really be pursued with caution. This brings me then to my 5th and final consideration that I would like to put out into discussion when it comes to creating an integrated system of protection. And this relates to the connection between international human rights law and international refugee law, specifically in terms of the Convention on the Elimination of All Forms of Discrimination Against Women, or CEDAW. As has been mentioned, the CEDAW committee launched General Recommendation 40 on the equal and inclusive representation of women in decision-making systems. And the recommendation holds provisions on gender apartheid, calling for its codification in order to create full accountability for gender-based crimes. And so the explicit reference and actual definition of gender apartheid in the document is quite notable. For one, it draws a concrete connection to the outlined developments in international criminal law. And this connection also exists in the fact that, again, already mentioned that Canada, Australia, Germany, and the Netherlands announced that they will take the Taliban in front of the ICJ for gender discrimination under the CEDAW Convention, and we're awaiting this to move forward. And so tying these varied connections between different areas of international law back to international refugee law and CEDAW, and in fact, bring it back to the first consideration that I discussed, namely adding gender to the refugee definition, I would like to conclude by pointing out that there's room for this when we're looking at CEDAW General Recommendation number 32, for instance, which supplements the Refugee Convention by stating that states are to apply a gender perspective when interpreting all 5 protected grounds, that they use gender as a factor in recognizing membership of a particular social group for granting refugee status under the convention, and to further introduce other grounds of persecution, namely sex and/or gender, into national legislation and policies relating to refugees and asylum seekers. So again, in this way, Recommendation 32 offers a framework for the mentioned addition approach, while it also highlights the importance of the connection between international human rights law and international refugee law in creating an integrated system of protection to address gender apartheid. And so together, these 5 considerations allow for ongoing discussions on this topic. And I hope that my brief outline of each will inspire further discussion and exploration here today, as well as moving forward. The importance of the topic was laid bare by the experiences of my colleague Lida and the millions of women and girls living under gender apartheid. And I will certainly continue to write and advocate around these points as this forms a primary research focus as part of my project on gender apartheid and asylum. And so thank you for the opportunity to share these insights from my work.
Thank you, Dr. Lara Susan. And I do have to say, part of the inspiration for this event was Dr. Lara Susan's amazing articles on this topic. So I think it would be really helpful if you could drop the links to those articles in the chat so that anyone who wants to read more about this on an in-depth level can definitely use your articles to see that, because as we know, we want to address the issue that's going on in Afghanistan, but at the same time, we also need to recognize that some of the Afghan women right now are being displaced, and we have to recognize those displaced Afghan women as well. So thank you for that. We will now be moving on to our last closing presentation by Ivana Kristic, who is from the UN Working Group on Discrimination Against Women and Girls. And she will specifically be giving a presentation on gender apartheid and how this is seen as part of the global gender backlash that we are seeing today.
Thank you so much. Good morning and good afternoon. Thank you for the invitation to join you today to speak about this very important topic. And I have to tell you at the very beginning that I join you today deeply inspired by the strength and resilience of Afghan women and girls. Their courage compels us to speak out, to challenge injustice and demand accountability. And their resilience reminds us that gender apartheid is not just a legal term. It is a lived reality demanding urgent action. And as you said in my introduction, I will speak today from the perspective of the Working Group on Discrimination Against Women and Girls, which has been closely monitoring the situation in Afghanistan, but also in other regions where systemic gender-based discrimination persists. Last year, in 2024, Working Group developed a guidance document on gender apartheid, which argues for its recognition as a potential crime against humanity to be included in the Convention on Crimes Against Humanity currently under negotiations. The guidance document points out that gender apartheid is also understood as a grave and systemic human rights violation under the existing international human rights law. Moreover, it is recognized as a violation of a jus cogens norm, by analogy and extrapolation of the prohibition of racial apartheid, currently recognized as an imperative norm. Thus, it is not merely a pattern of isolated policies. It is a systemic and institutionalized form of oppression that demands urgent legal recognition, accountability, and reaffirmation of substantive gender equality. The recognition of gender apartheid as a crime against humanity is vital, not only to hold perpetrators accountable, but to ensure Afghan women and girls receive the protection and justice that they deserve. As a result of the joint visit of the UN Special Rapporteur on Human Rights in Afghanistan and the former chair of our working group, Dorothy Estrada Teng, to Afghanistan in 2023, and the joint report which was produced as a result of this visit, we were able to evaluate firsthand the dire situation of the human rights of women and girls in the country, which has become worse since then. The experience of Afghan women under the Taliban regime are a stark reminder of why codification of gender apartheid is essential. More than 100 edicts issued by the Taliban de facto governments restrict the rights and freedoms of Afghan women and girls in all spheres of life: public participation, political life, economic and social life, health and safety, and family and cultural life. Women told us, "We are like prisoners in our own homes." This is an attack to the core of human dignity of women and girls, and at the same time, it is the gravest manifestation of a broader phenomenon of global gender backlash that the working group, first of all, warned against since in 2018, so 6 years ago, or now even 7, and most recently mapped in detail its escalation in its latest report to the Human Rights Council, which was presented last year in 2024. Unlike women and girls in most other countries who have the right to study, to work, and move freely, Afghan women are being denied these fundamental human rights. And this is not the result of cultural differences or social practice. It is the deliberate design of a systemic and institutionalized structure intended to suppress and erase Afghan women from society. This is exactly what we call for, saying that this is that gender apartheid looks like in practice. This is a state-imposed system of subjugation that deprives women of their autonomy, independence, and basic dignity. Afghan women are not merely victims of discrimination. They are the targets of a comprehensive system designed to deny them their fundamental rights and freedoms. The intent to erase women's and girls' human rights to the extreme has also facilitated the reinforcement of harmful practices and gender stereotypes, as well as patriarchal attitudes and actions towards women and girls, including in some cases by family members. Despite the scale of the crisis, the international response has been slow and fragmented. Countries such as Canada, Germany, Australia, and the Netherlands have invoked CEDAW to challenge the Taliban's systemic repression of women. At the same time, Chile, Costa Rica, Spain, France, Luxembourg, and Mexico have referred the situation to the International Criminal Court, seeking to hold the Taliban accountable for their actions. As has been mentioned, the request for arrest warrants by the ICC prosecutor against 2 Taliban leaders and the possible ICJ case by Germany, Australia, Canada, and the Netherlands against Afghanistan for its violation of CEDAW open windows of hope for global accountability and also demonstrate that international mechanisms can be triggered to defend gender equality and non-discrimination as central pillars of the international system. These actions signal that gender apartheid must be recognized as a distinct and punishable crime, one that demands both accountability and protective measures for survivors. Our working group has repeatedly stressed that states must not only respond with words, they must take concrete legal and policy steps to hold perpetrators accountable and provide effective protection mechanisms for women and girls. A multi-layer approach to protection is essential to effectively address this crisis. The working group makes itself available as always, to support the struggle of Afghan women and girls and to push all actors to place their voices, proposals, and ideas of Afghan women and girls at the center of any conversation about Afghanistan and its future. We call again for donors to provide long-term, flexible, and sustainable funding to organizations led by Afghan women and to ensure their meaningful participation and decision-making in any discussion on the region in line with the Women, Peace and Security Agenda and with the recently issued CEDAW Committee's General Recommendation number 40. We also call upon third states to grant refugee status and the regular resident status to Afghan women and girls and their families, ensure non-refoulement principle, and facilitate their access to an exercise of all their human rights. Displaced Afghan women and girls must have access to education, healthcare, and employment opportunities in their host countries to ensure their continued empowerment and independence. Support networks for displaced Afghan women must be strengthened to empower them to advocate for themselves and their communities. States must continue to amplify Afghan women's voices and ensure they are included in global discussions about peace and security. And above all, Afghan women and girls must be given the opportunity to lead. They are not passive victims. They are advocates, educators, change makers. Their voices must shape both policy and responses and legal frameworks addressing gender apartheid. We also call upon all mechanisms to provide gendered reparations to Afghan women and girls and to continue this struggle as part of our shared humanity. Upholding the universal human rights of Afghan women and girls is crucial in and of itself and is also essential to defending gender equality for women and girls everywhere. Dear colleagues and dear friends, gender apartheid is not only a violation of human rights, it is an assault on human dignity. Silence in the face of such oppression is complicity. We must refuse to look away. The struggle against gender apartheid is a fight for freedom, justice, and equality. Let us stand together to ensure that Afghan women are no longer silenced, but are instead heard, protected, and empowered. Thank you so much for this opportunity.
Thank you, Ivana. It really means a lot when the working group comes forward and says something. It's not just words to communities around the world. It's acknowledgement of people's lived experience and lived realities. So the fact that the UN Working Group on Discrimination Against Women and Girls is so willing to come forward and say that this is gender apartheid, that gender persecution should be recognized when it comes to refugees, and even gendered reparations is something too that may not be so widely accepted, but the fact that the working group is coming forward and opening up this conversation is so important. So thank you so much for giving this statement. We will have around 10 minutes for Q&A, and I'm seeing some question and answers, some questions. So I will pose this to our panelists. Feel free, whoever wants to take up the question, to unmute yourself and begin answering it. The first question that we have, and I will add a little bit to it because I'm also curious about this, is how can potentially including gender apartheid and the Crimes Against Humanity Treaty and all of this work that we're doing connect to domestic violence that may be going on at home in countries around the world. Specifically, we know that violence against women is also not currently codified in an internationally legally binding treaty. Is there some way that this can connect to an optional protocol to CEDAW for violence against women? How do you see these issues connecting? Yeah, you say go ahead.
Thanks for the question. The one thing that I have to say is that the gender apartheid framework is really maybe one of the more extreme manifestations of what is happening to women and girls around the world. And so, we get this question a lot, actually, around what does this apply to? And I've been in varied conversations where people said, there's a gender apartheid happening in the US. There's gender apartheid in Nigeria and certain places. Like there's different interpretations of what that can look like. what we're saying with the definition is something that's very clear, and also there's a threshold requirement to be able to meet that. And I think that's one reason that there are states that are prepared to sign on to that and acknowledge, you know, this as a distinct crime that needs to be codified. One thing that we always, you know, preface our comments with is that misogyny and patriarchy exist everywhere, right? And also there's many countries in which most countries around the world have problems of you know, culturally or women not being empowered in the home, or domestic violence issues. But I guess what is super extreme about the countries that we're talking about that meet the definition of, you know, where individuals are committing the act of gender apartheid and officials are really feeding into that framework, is where it's enshrined in the law. So that subjugation is enshrined in the law and it is being enforced. And it's very much for this distinct intent of propping up the ruling regime and subordinating that subjugated class for that purpose, and an exploitation of that class. So it's a very extreme manifestation. Not to say, I think hopefully that will help illustrate the spectrum and the continuum of how women's rights are violated, even looking at the differences between Afghanistan and Iran. In our view, the Islamic Republic of Iran is committing the crime of gender apartheid, but on the continuum, it's obviously much less severe than the situation in Afghanistan, because of the fact that what the Taliban doing is essentially, the bar is really in hell when it comes to that situation. So it shouldn't really be a standard for anything, obviously. But anyway, I hope what it will do is encourage a conversation around the spectrum and the continuum of how women's rights continue to be violated across the globe.
Yeah, I agree. Violence against women doesn't show up in one way. And so we do need these responses to be in different ways in order to account for that. Tess, I think you wanted to add something to this?
Yeah, thank you so much. And I wanted to just add that I think often when we're talking about sort of new ideas about codifying or re-articulating different ideas in international law, it rightly generates excitement about how it could apply to a particular context. I would agree that you know, the term gender apartheid applies to sort of these most extreme examples, but that doesn't mean that things like domestic violence and epidemics of domestic violence and you know, continued state failure to address domestic violence, just because that isn't gender apartheid doesn't mean it's not a human rights violation, and B, potentially criminalized or, you know, generating state responsibilities, including potential criminal responsibility under other legal regimes. So we are talking about a specific legal concept of gender apartheid, but for example, continued state failure to deal with systematic or widespread domestic violence would certainly amount to violations of CEDAW, as we've discussed, the Convention for the Elimination of All Forms of Discrimination Against Women. It could also potentially arise to different, you know, if state authorities are failing to criminalize domestic violence in their domestic context, under that could potentially give rise to some legal responsibilities under other treaties, potentially even under a Crimes Against Humanity treaty. So yeah, I think it's important to retain the specifics and the gradations in these legal definitions, because if we start to collapse the definitions together and say that all forms of gender discrimination are gender persecution, are gender apartheid, then we lose the ability to talk with nuance about how severe some of these situations are, such as the Taliban. So just agreeing that it doesn't necessarily apply to domestic violence in general, but that that doesn't mean that that isn't internationally recognizable and cognizable problem.
Thank you for that clarification. And Lida, you want to add on to this as well?
Yes, sure. I will be quick. I just have 2 points. I think what I see again, my experience and if I can say, put it this way, like the case study and the personal experience is the case of Afghanistan. So I think to address the domestic violence issues and stuff, first we need to realize who are enforcing the rule of law. We don't have a lot of women in the law enforcement agencies, and it's kind of still taboo. And women who joins these forces, they're still looked down and they're not appreciated. So we need more women to address the issues. If women go through different cases, they know that when they go to those law enforcement agencies, there are women who can listen to them, not men who actually perpetuate those types of violence. Because there is a lot of research that women in power, and specifically in the police and in other departments, they actually have high rates of domestic abuse than even an average man who does not have that certain type of power. And the second thing is, it's not enough to just for women to realize that something is going wrong and I want to reclaim my power, I want to fight for my freedom and stuff. It's also to help men understand that they're doing something wrong. And I think it's the irony is that we talk about women's side, but if men does not accept that they're doing something wrong, there's an issue. So I think there should be a lot of focus on how to engage men, help them realize that what they're doing to women or the violation of women's rights, it's not okay. There is a fundamental problem there. And unless they come to the table and accept, say, okay, this behavior or certain things that we're doing are not right, I think it's a one-sided battle. So more awareness campaigns for the men.
Thank you, Lita, for that wonderful addition. We'll go on to at least one more question. I think this one is tailored to Dr. Lara, Susan, and Ivana from Mariam, who is an Afghan female student. She is asking, what are the protections for students from the Taliban to ensure that students, specifically female students, can leave Afghanistan without obstacles to pursue education? Should there be a particular organization from the UN that should facilitate this protection? What do you guys see as protections for specifically female students from Afghanistan?
I don't know if you would like to begin, but I can share a few thoughts on this from my research. And again, this particular area of education and receiving protection based on this is not my area of expertise, but here we're talking about different pathways, right, to be able to actually access protection, but that is not necessarily considered under the strict framework of asylum, because as mentioned, gender does not currently constitute a standalone ground of protection under the refugee definition. So we're talking about within international refugee law, we're talking about alternative pathways that can still ultimately get to a similar outcome, which means a destination country ultimately receiving individuals. And so I think to me, this of course is one way of overcoming some of these obstacles, but it doesn't at the end of the day address what the core issue is, as I would argue, which is that gender needs to be a protected ground for asylum. And so we've seen different ways or different mechanisms of going around this. And so that's where I would leave it at this point. I'm curious to hear what Ivana, her thoughts on this.
Thank you, Lara, so much. First of all, before I respond to this question, I would like to respond also to the first one, when we also make a distinction of gender apartheid and in some other cases where we claim that we have discrimination or domestic violence or whatever. I really think that it is really important to take into account the elements of the system that we have in Afghanistan. And the elements are institutionalized regime of systemic oppression and domination. So we don't have this scale of structured, organized, deliberate system as it is in Afghanistan at the moment. There is also another element that I would claim is very important, and this is an intent to maintain the system. And it really is not just a very generic or individual cases of discrimination, but it is intention to maintain the system. Also, we have involvement of inhuman acts, in some cases also torture or degrading acts, which as a result have denial of basic rights. And the scale also shows that this example is in that way not comparable to some other cases. And also, I would say that it's also very important to see what is the purpose of perpetuating inequality in this specific case, which means that when we have institutionalized and systemic oppression, the system is aimed to preserve the privileged position of a dominant group, and at the same time to subjugate the oppressed population. So I think that all these elements are very clear and very visible in the case of Afghanistan, and this is why also the working group claims that it is gender apartheid, apart from all other violations that we've seen and that I mentioned during my presentation. When it comes to students and education, I very much like the presentation of Lara and her claim on the recognition of refugee status for women and girls coming from Afghanistan. I think that in that case, they can get a host country support, and it would be very valuable to see what specific countries have special asylum programs, and to develop further programs to allow women and girls to continue their education. Then I would also say that maybe the network of safe space in Afghanistan is also, I would say, at this moment, a very important step forward to allow them to continue and to study, apart from what Lara already said, and I very much agree with her recommendations or her proposals in this case.
Thank you so much for all of your contributions. We have one more question, but we won't have time for it because I do want to respect everybody's time. And it has to do with national court cases. So I will reach out to our speakers to see if they have any insight on how gender apartheid has been addressed in national cases, and we will send that in the follow-up email. But thank you, everybody, for coming to this event. We will share all of the resources and the links that were sent in the chat, also in the follow-up email to all of the registrants. And I hope you have an amazing rest of your CSW, and you continue to do advocacy to make sure that gender apartheid is included in things like the Crimes Against Humanity Treaty and so forth. So thank you, everyone, for joining, and have an amazing rest of your day.
Thank you so much.
Thank
Bye.
you.
Bye.